That's here on In Focus. Now, most sections of the long-awaited Protection of Personal Information Act, known as the POPI Act, come into effect tomorrow. The act is intended to protect consumer privacy, requiring organizations to obtain prior authorization if they process certain categories of personal information. The Chief Executive of the South African Human Rights Commission, Advocate Tseliso Thipanyane, joins us now to break this down for us so that we get an understanding. Advocate, good evening and thank you very much for your time. Tell us more about this new data privacy law that is kicking in from tomorrow and what it means for us and how we need to be prepared for it.
No, thank you. You know, the Constitution provides for two rights which are relevant in this context: the right of access to information as well as the right to privacy. So the new act, which will be coming into operation tomorrow much fully, basically protects privacy through protecting our personal information. At the same time, the act also provides for the establishment of the information regulator, which will also be managing the protection of the Promotion of Access to Information Act, that's POPI, as well as then the Protection of Personal Information Act.
Failure to comply with these new rules, what would that mean?
Well, you know, unlike the Promotion of Access to Information Act, which was managed by the Human Rights Commission up until tonight, the information regulator under POPI has greater powers to enforce compliance with the Act, and you can actually be fined up to 10 million rands if you fail to comply, and if you fail to protect the personal information of individuals as well as entities in this country.
So you mentioned earlier on that this, of course, will now mean that the right of South Africans to privacy that is afforded them by the Constitution will actually be enhanced. So does this mean no more unsolicited calls?
Yes, no more unsolicited calls, no more sharing of personal information without permission, as well as the holding of personal information. So you can see already tonight there are lots of activities on the internet where people are asking you whether they can still keep your information, do you have any objections. Also, I mean, for example, when you go into these gated communities where people request your ID, that's personal information which has to be protected. Also, if we take into account the context of cybersecurity, where through technology now, people's information is being stolen all the time and can lead to massive challenges as far as their privacy as well as their wealth and many other things.
As a whole case around Mark Zuckerberg and the policy changes to WhatsApp and what happens to that data, but part of what the POPI Act now says is that companies can only collect what is necessary and have a legitimate reason to collect that information. What does that mean? What constitutes what is necessary?
Well, yeah, the Act then, explains clearly, what that means. It must be the least intrusive, in terms of your access to information. But also your consent has to be given. I think that was already the problem which we saw earlier on, where WhatsApp was basically demanding people to sign up, and of course the information regulator was having concerns about that. So the Act really is to give back us our sovereignty, our right over our own information, and therefore it must only be used with our consent or where the Act allows for exceptions.
So is this going to impede free flow of information? For example, I mean, we're already seeing now on WhatsApp, when you forward something probably 4 or 5 times or to 4 or 5 more people, and that already gives you a warning to say, well, this particular video clip has been forwarded too many times. Is this going to inhibit the free flow of information?
Well, it regulates. There's no absolute right. Just like Access to Information Act has got limitations. So the same issue that the usage of personal information also has limitations. So we do have to have a balance between the two interests. Access to information, because remember, in terms of the Constitution, you have access to information in the possession of the state or any other individual, as long as it's required to advance your rights. At the same time, then you have the right to privacy, which means your information must also be protected. So we do need to find a proper balance between these two interests so that we don't impede progress unduly.
So tomorrow, if I go to a shop and I purchase something and they say, well, let's get your name. I'll go to a pharmacist or wherever. And they say, let's get your name, let's get your details, and let's get your address. I must now not be afraid that it will be sold to some marketing company and I'll be getting some sort of message. The requirement is that now, when I do write that information, that particular business needs to keep my information and protect it and not share it.
Yeah, information. So personal information in the possession of other entities like companies has to be protected, and the Act then provides a very clear requirements as to how the information should be protected. And if it's not protected, and then the information regulator can actually fine you up to 10 million rands, depending on how big you are. So as from tomorrow, people have to make sure that whoever is in possession of any other person's information, that information is secure to avoid, it being stolen and therefore undermining the privacy of individuals. So government departments, institutions like us, which, keep lots of personal information, your name, your ID, and where you stay, that information has to be protected. Secondly, it means that information cannot just be shared to anybody else without permission. That's why, for example, up until tonight, you still get a phone call, people calling, you don't even know where they got your number from.
Now, in countries where similar data laws have been put in place, certain companies have actually gone bust. In fact, they are data collection companies, which is their business model. How are they accommodated in this particular act, and what happens to them at this particular point? Does it mean they must just close shop?
No, they will still operate, but they have to operate within, the law. I mean, banks, for example, keep your information. They cannot survive without your information. But that information must be used in accordance with the Act and must not be abused. So if you are in that business, then you have to familiarize yourself with the Act and make sure that whatever you do, you protect that information. But also what is important, that information you should have with the consent of the individual. That's why I'm saying, tonight I've been getting so many emails from companies. We have your information in our possession. Can we use it? And if you don't object, it means you're okay. Because that is what is required now. You can't just distribute anybody's information without that permission, except where the Act allows.
What does the Act say? I mean, you've mentioned that you've received tons and tons of these messages giving you an option to opt out, right? Now, if I've bought my 55 Rand or 29 Rand or even 10 Rand airtime and I receive 10 messages, people saying I can opt out, and every time I send an SMS, it charges me 1 Rand. It's certainly not going to work out nicely for me. What do I do?
Well, actually, what the messages I've seen now is people are saying, if you don't opt out, it means you are consenting to that. I don't know how the information regulator will deal with that. But yes, that is one challenge, unfortunately, that you'll be getting all these messages, and using your data as well, which takes it to another issue that, at some point in time, we need to address the issue of whether internet should actually be a human right and should be freely available.
If you have a business today, what would be the advice that you need to do, particularly if you're dealing with people's information?
Well, all entities have to register as information officers, and in terms of the Act, unfortunately, there's been some challenges there. So just like, for example, with POPI, which we're managing, all public entities and many private bodies have to, register with the information regulator, given the names and particulars of the information officer, and then also, what kind of information is being stored. So, that's what businesses have to do. Unfortunately, as I was saying, due to some of the challenges, the information regulator has actually given an extension for people to fill in the forms and register as required.
Advocate, I appreciate your time and thank you very much for joining us tonight. Advocate Tseliso Thipanyane, the CEO of the South African Human Rights Commission. They're giving us an update on what now needs to happen with the POPI Act kicking in. That is the 1st July, that is tomorrow, which means now people need to protect that information and protect that right of individuals' personal information as protected in the Constitution.